Hello friends. Today we gonna study about the Industrial Relation Code 2020. This is one of the 4 code covered under the Labor Code. It provides a broader framework to protect the rights of workers, to make unions, to reduce the friction between the employers and workers, and to provide regulations for settlement of industrial disputes. The code is prepared after amalgamating, simplifying and repealing following 3 central labor acts: the Trade Unions Act, 1926. The Industrial Employment Standing Orders Act, 1946. The Industrial Disputes Act, 1947. Applicability. Particulars. Applicability. Under previous law. Applicable to establishments with at least 100 employees. Industrial Relation Code. Applicable to establishments with at least 300 employees. Employees coverage. Only specific workforce in cover under the definition. All the employee, whether skilled, unskilled, or working at any position, is cover in this definition. Prior permission for lays-off, retrenchment and closures. Applicable to establishments with at least 100 employees. Applicable to establishments with at least 300 employees. Electronic filings. The old acts did not have specific provisions for electronic filing. The IR code provides that procedures and filings can be made electronically. Penalty and offence. For failure to certify standing orders or the modifications to the same and comply with the finally certified standing orders, fine which may extend to 5,000 rupees, and in the case of a continuing offence with a further fine which may extend to 200 Indian rupees for every day after the first during which the offence continues. Penalties are more stringent now. Up to 200,000 Indian rupees. In case of non-certification of standing orders, an additional fine of 2,000 Indian rupees per day during which the contravention continues. In subsequent contravention of the finally certified standing orders, fine up to 400,000 Indian rupees and imprisonment for a term up to 3 months, or both. Objective of Code. The Code designated to safeguard the rights of employers and employees by providing easy labor reforms and to facilitate ease of doing business. The object of the Code is to realize industrial peace and harmony as the ultimate pursuit in resolving industrial disputes, and to advance the progress of industry by bringing about the existence of harmony and cordial relationship between the employers and workers. Threshold for applicability. Particulars. Threshold for applicability. Requirement. Works Committee. 100 or more workers. Constitution of Works Committee consisting of representatives of employer and workers. Grievance Redressal Committee. 20 or more workers. Constitution of Grievance Redressal Committees for consisting of equal number of members representing employer and workers. Preparation of draft standing orders by employer. 300 or more workers. Employer must prepare draft standing orders within a period of 6 months from the date of commencement of this code. Notice of change in conditions of service. 300 or more workers. Employers who propose to effect any change in conditions of service applicable to any worker in respect of any matter under the 3rd schedule shall effect such change by giving 21 days notice to workers. Duty of an employer to maintain muster rolls of workers. 50 or more workers. It shall be the duty of every employer for the purposes of this chapter to maintain a muster roll, and to provide for making of entries therein by workers who present themselves for work. Contribution to Worker Reskilling Fund. Contribution of the employer of an industrial establishment that is equal to 15 days' wages last drawn by the worker immediately before retrenchment. Comparison. Particulars. Under previous laws. Industrial Relation Code. Definition. Definitions. Employee. Fixed-term employment was not defined in any of the Act changes in definitions of strike, wages, industrial dispute. Layoff workman was defined in the Industrial Dispute Act. New definition of employee, fixed-term employment introduced. Definition of strike has been amended to mass casual leave by 50% or more workers on a given day, while the definition of wages kept aligned with other labor code. Workman now renamed as the worker. Negotiating union. No provision for negotiating union. Recognition of negotiating union is mandatory. Proceeding, No time limit mentioned for completing the disciplinary proceedings against the worker. Investigation and inquiry have to be completed within 90 days from the date of suspension of a worker. Strikes. Prior notice condition was only applicable to public utility service industries. 14 days prior notice before strike mandated for all industrial establishments. Reskilling Fund. No concept for Worker Reskilling Fund. Chapter 11 introduced around Worker Reskilling Fund. According to the provision, the employer will be required to deposit an amount equal to 15 days' last drawn wages of every retrenched worker. Grievance redressal. Industrial establishment having 20 or more workers shall constitute one or more grievance redressal committees with a maximum 10 members for resolution of disputes arising out of individual grievances. Grievance redressal mechanisms under the Code. Bipartite forums. Works Committee and Grievance and Redressal Committee. Conciliation Officer Voluntary Arbitration. Industrial Tribunal. National Industrial Tribunal. Closure of industrial establishment. Employer intending closure of an industrial establishment is required to serve 60 days advance notice to the government. Provision for compensation in case of closure to those workers who are in a continuous period of service not less than 1 year. We hope you have enjoyed the video. In case you like the video, press on subscribe button and click the bell icon. For personalized query, you may reach out to us at info@baglobal.in.